Good afternoon, everyone, and welcome. I'm really thrilled today to have a terrific panel of guests to talk about what's going on with the Trump administration, with DOGE and personal data and surveillance and privacy issues. We're hearing a lot in the news every day. We're hearing stories about DOGE entering into agencies, exfiltrating data, gathering data, using data, making deals with the IRS to get data. So we're hearing a lot of things going on. And I'd love to dive into these things to learn and discuss what's happening and then what's being done about it. The cases that are being brought to find out more information, to challenge what's being done. How do existing laws address what's being done? Is what's being done legal or not legal? How should we think about it and look into that? So with me, I have a really wonderful array of folks. Mario Trujillo at EFF and Mark Lemley at Stanford Law School are involved in bringing a case involving some of this data gathering by DOGE. And so we're going to talk to them about their action. We also have Alexandra Reeve Gibbons from CDT. CDT is very involved in these issues and is keeping track of what is happening and all the different actions and things that are going on, and they're in the thick of it too, involved in fighting back against various types of privacy invasions and government surveillance efforts. So I'd like to start actually by just beginning to talk about DOGE, and in particular, what exactly is DOGE? Because it's a little confusing exactly what DOGE is. Is it an arm of the government? Is it not? Is it some just kind of, how did it come to be and what is its status? Because that impacts the way the law interacts with it.
Yeah, I'll take the first shot at that, I think, right? So the short answer is, like with so many things in the Trump administration, nobody knows, and it seems to change day by day. So I think the original idea was Elon Musk was going to kind of run an outside advisory group that would come up with ideas for cuts in the government budget. And, you know, as an outside advisory group, you'd be subject to one set of rules. You would not be a government employee, but you also wouldn't have any actual authority. Starting on January 20th, it became clear that that was not what was happening. He was actually sort of coming into government agencies, including OPM, which we'll talk about in a minute, and sending his own employees, his own personal employees from the private sector, now designated DOGE employees, in to embed them in those agencies, get access to their computer networks, get access to all of the data contained therein. People immediately said, well, hey, wait a minute. Are you this isn't a government agency. There is no congressional authorization for an entity called DOGE. Their response was to sort of declare that the sort of DSS, the digital services portion of the government, which had been running computer services, was now going to be renamed DOGE, and they would essentially take over that group. Even that didn't really happen, right? Because at various points, the administration has taken the position that Elon Musk is the head of DOGE, running a government agency that they have taken over, and that the employees of that agency are government employees. But also the position directly contradictory to that, that Elon Musk is not a government employee. He is not a government agency head. There is a woman who was on vacation in Costa Rica when it was announced that she was actually the person running DOGE, even though there was no reason she had think she had any relationship to it. And so they have at various points in the litigations taken the position that, hey, everything we do is within the scope of the Administrative Procedures Act because these are all government employees, and the contradictory position, sometimes in the same lawsuits, that these are not government employees and therefore they are not subject to FOIA requests, to record retention, to public meeting requests, and the like.
Anyone else have anything to weigh in on DOGE and its status?
I mean, I think it's worth noting with a hint of mourning that this was really a host cell takeover of the United States Digital Service, which was a team that was developed during the Obama administration with the notion of using technology to help improve government service delivery and make sure that government was working for the people. So that irony can't help but be noted when a lot of the ways in which the tools are being used now are obviously directly counter to the interests of people receiving government benefits and services.
Yeah, and one thing to note is in the January 20th executive order that sort of renames the U.S. Digital Service to DOGE. The stated mission is IT modernization, which no one is against, and is what U.S. Digital Service was doing. Evidence that is not their real mission is that about a month into the administration, 21 sort of legacy U.S. Digital Service employees quit, saying that sort of siphoning all of this data, insecurely holding it is not the stated mission. We're not going to sort of adhere to that as engineers, and we're going to quit.
Yeah, it seems like this is part of an overall tactic by the administration just to shroud everything in ambiguity, mystery, make all sorts of justifications that don't fit, hoping that they'll get deference or some kind of big extended debate over what exactly is going on, which I think is the point, right? You spend so much time figuring out, okay, what is this? Is this actually what it said? No, it's not. And that siphons off a lot of time and effort. In the meantime, there they go, and they've already done a lot. And we've been reading in the media a lot of things that are going on. And I'd love to just kind of hit some of the highlights about what you're aware of what's happening in terms of the data that's being accessed and taken out. And just with the caveat that, the reports I'm hearing are very ambiguous and no one fully knows all the details. But, I just read a story about, the IRS made a deal to share data that it's not clear they had the authority to do that, to share this data with the administration, with DOGE, if it is the administration, which I think it is, or not. It's kind of both. There's that. And a number of folks resigned or were kind of forcibly pushed aside when that effort was done. There was recently a story about the DOGE going into the NLRB and exfiltrating a lot of data against the wishes of the people there who were trying to resist that, but again, were kind of shoved aside and they got this data. And so we have that story. And then there's the basis of your lawsuit, the gathering of data about government employees. Is there anything else that is going on that you've been hearing about?
Oh yeah, absolutely, right. I mean, probably we could spend the whole hour just listing things, but let me. So on the IRS point, right? I do think it is notable. It's pretty clearly illegal. But let me just sort of flag two others which strike me as particularly noteworthy in how shocking they are, even by Trump administration standards. One is the idea that the information that is being scraped, right? Government employee information, all of the Social Security records from everybody in the country, all of the IRS records are being fed into the Grok AI database. right? Ostensibly so that we can have a kind of single integrated AI for government information that has access to all of this information. That strikes me as scary enough from a privacy perspective. There's a reason we compartmentalize this information, right? There's a reason we don't actually share everybody's tax records with anyone in the government. But because it's Grok, because it's Elon Musk with his sometimes government hat, sometimes private hat, right? There's no reason to think that information isn't also then going to be used for private benefit outside the government. So that's one. The other one I want to flag because this strikes me as perhaps the most evil thing the administration has done, and that's a really hard standard to meet, is having collected the information from Social Security, they are manipulating the Social Security death master file. That is your Social Security records. When you die, we record you as dead, so people can't continue receiving benefits. But every private entity relies on that information. They have declared a number of living people to be dead for Social Security purposes, precisely in order to prevent them from functioning in society. Prevent them from having access to a bank account, prevent them from having access to credit cards, prevent them from having access to any government services, driver's licenses, or anything else. So when we talk about sort of what might happen if they get access to this information, they are already using this in ways that are, I think, sort of would have been unimaginable even in people's worst case nightmare scenarios 6 months ago.
Yeah, and one other that I'll add before maybe pulling back to the bigger picture, there's a recent reporting about plans at the Department of Housing and Urban Development about revoking the housing benefits for people, in particular in mixed status households. So both a new rule to make it impossible for people to apply for such housing, but even then now querying, are there people currently receiving those benefits? Some of whom, are in mixed status, undocumented households. So that's the type of weaponization of this data that we're seeing. But it might be helpful to pull back first just to kind of remind people about the treasure trove of information that our government has about us, often for very valid reasons, right? It's how we're able to engage with the government. It's how we're able to access services. And why, to the point Mark was making earlier, there have, for so many decades, been important legal protections in place, the Privacy Act, sector-specific rules like the tax code, to make sure that that information is protected and people can trust when they share it with the government. The New York Times had a really useful infographic that kind of walked people through. New America Foundation also has a quiz you can take, what information does the government have on me? And it's everything you can think of, right? From date of birth, social security number, your citizenship status, your address, disability, marriage, divorce. But then there's also the type of information that you were alluding to, Dan, that individual agencies may have about you because of the type of interaction you had with them. So for example, Wired had this very big story that broke over the weekend about a whistleblower coming forward from National Labor Relations Board and saying that it looked like there were bulk exports happening of the case management system that NLRB maintains. Think about the information that is disclosed in the course of a National Labor Relations Board case, right? That's whistleblower information. It's sensitive company information about allegations of wrongdoing that were taking place. And those types of case files are also held at other agencies across the government, the Equal Employment Opportunity Commission, the SEC, Securities and Exchange Commission. You can think about what the Department of Justice has through its victim services. All of that is not only kind of high-level name information, but detailed case information as well. And right now we have so little visibility into what these exfiltration practices might look like, why the data is being reviewed and accessed, and what is being combined into these mass databases, that it really begs the question, why is that access needed? And what happens when we no longer have confidence that those records are being protected?
Yeah, and you mentioned a whole bunch of different agencies. I think the narrative is the same. The agency changes, the sort of misuse of information changes. There are lawsuits against the Treasury Department, the Office of Personnel Management that we're a part of, the Department of Education, the Social Security Administration. but just focusing on the data that the Office of Personnel Management has. This is kind of seen as the HR department of the government. It has the records of more than 22 million current government employees, and then also federal government employees, and possibly their family members' information as well. And so that includes social security number, race, disability, employment information, union activity. We're representing a number of unions, health records, financial information, and family information. And so this information, at least at the Office of Personnel Management, can be used, just giving individuals who are unvetted and untrained access to the information without a need. First, giving the information away itself is sort of a harm in and of itself, but it also makes these systems a lot less secure. And then specifically to this OPM data, it raises the question of creating sort of enemies lists, creating information or giving people information to either fire people or to retaliate against them. We've seen the Trump administration sort of bring executive orders against individuals, former government administration officials like Chris Krebs. And so this information, even of former government officials, is quite sensitive. And the Privacy Act was created 50 years ago specifically to protect not only the general public, but government employees specifically.
So I'd love to talk about the specific suit that you're bringing, and then broaden out to some of the other cases that you've heard about, or some potential cases. And then also, I'd love to also talk about remedies, like how do we, if you win the case, can we really patch this up and stop this? So you brought a lawsuit very recently representing government employees against OPM and a bunch of other parties, DOGE and others. I'd love to hear about this lawsuit. Can you tell me about the suit and the basis of the suit and details about it?
Yeah, sure. So it's essentially we're bringing the case against two entities: the Office of Personnel Management, which is essentially the HR department of the government, and then also DOGE and its affiliates. And we're alleging two basic things. One, that OPM illegally disclosed these records to DOGE agents who have no need for it, and then also just both agencies are poorly securing these records. And so this creates a sort of a number of harms. First, the disclosure itself is a harm. It's sort of a broken promise of the government. Many government employees gave their information to the government for specific purposes, with the understanding that they wouldn't be used for other purposes. And so just like the basic disclosure without a need is a harm in itself, but it's also created these downstream risks of a potential data breach. OPM about 10 years ago suffered one of the largest government data breaches in history. It breached about 22 million people's information and caused a whole ton of harms and a whole bunch of lawsuits. And so sort of infiltrating that agency in particular creates a lot of cybersecurity risks. And then, as I mentioned earlier, putting this information in the wrong hands creates a lot of retaliation risks from the government itself. And so we're basically asking for two very simple remedies. One, to ask the OPM to order the OPM to stop disclosing that data to DOGE in violation of the Privacy Act. And then the second remedy is for DOGE to delete or give back the information that it's already disclosed. And so that is sort of trying to remedy the harms that have already happened, understanding that the harm can't be completely undone, but it can be we can sort of staunch the bleeding. And that's what we're asking the court to order.
And let me just sort of note, like this is not a part of the current lawsuit. I'll tell you a little bit sort of like where we are procedurally. So the government filed a motion to dismiss, which the district court denied a couple of weeks ago. We had sort of expedited discovery, acquiring the administrative record, and we are now in the process of filing a motion for a preliminary injunction, which should be filed within the next couple of days. And so our hope is that we will relatively quickly get an injunction in place preventing disclosure of this information to DOGE employees or others at OPM who don't have a need for it, and also preventing misuse of that information that has already been disclosed. Lurking behind that, and there is no current lawsuit, but I think there sort of can and should be willful violations of the Privacy Act, which this unquestionably is, are also give rise to a cause of action for damages. There is a statutory damages provision that allows you to obtain a minimum of $1,000 in damages plus any actual damages you can show. The Supreme Court a dozen years ago in FAA versus Cooper, in one of the more dramatic acts of judicial activism, decided that sort of actual injury should be interpreted not to mean what actual injury meant in any other statute, not to mean what Congress intended, but well, actual injury sounds kind of to us like special damages in defamation, and special damages in defamation means you must show financial injury. So 5-4, the Supreme Court in FAA versus Cooper engrafted a requirement on the Privacy Act that there be financial loss in order to qualify for the $1,000 minimum statutory damages. That's pretty clearly not what the statute says. It's not what anybody thought the statute said. And it's interesting that the 5 justices who did that, right, are the justices who in other contexts are happy to tell you that they are plain meaning folks who just follow the language of the statute and would never sort of creatively add a new requirement because they thought it was a good policy. But of course, that's exactly what they did in this case. The practical effect of that, I think, is what the law actually says, right, which is all of the 20 million current and former federal government employees who had their data accessed willfully in violation of the statute ought to get $1,000, is going to be rather more circumscribed. You would have to show some sort of injury. Now, I think all the people who have been fired illegally on the basis of access to this information are going to be able to show injury, a financial injury, obviously. If and when there is a sort of hack of this information because it is not being kept in a secure location, I think people will be able to show financial injury. Even something like, did I buy credit monitoring or sort of invest even a small amount to try to sort of protect myself after these disclosures would qualify as financial injury that would entitle you to $1,000. So I think there's a suit for damages kind of waiting behind this one, but how many people are entitled to recover those damages is going to be a more challenging thing to establish.
Yeah, I'd like to weigh in on, the Privacy Act generally is a federal law that regulates and tries to protect privacy of people's personal data maintained by government agencies. And it applies to executive agencies. Congress, of course, exempted itself, and the courts are exempted, but federal agencies, that is what the data that DOGE is gathering from, that would be covered under the Privacy Act. And this is an old privacy law. There are a lot of problems with the law. It regulates unlawful disclosure of the information as well as improper uses of the information. Its provisions on use are weak because there's just a lot of loopholes and other problems with use, although this is so egregious that it could very well trigger use violations. Because there are procedures for using the information under the Privacy Act that don't seem to have been followed. The disclosure of the information, it kind of depends on, is it kind of outside of the government or improper disclosure, and there could be some debates over that. And then Mark mentioned the problem with that it has injunctive relief, attorney's fees, and then also damages for individuals, and that's where the Supreme Court has done its mischief. It basically went against what is a clear statutory damages provision with a minimum of $1,000 per individual. It could be more if they prove more damages, but a minimum of 1,000. They just interpreted it away and said, well, even though the plain meaning says that, it requires that they have to prove damage. And I think it's going to be hard because the Supreme Court's other decisions, like Clapper, says, well, getting credit monitoring, doesn't count because you can't manufacture the injury. The other problem is, okay, you get the damages and then the government pays the damages. So the taxpayer is essentially paying the bill for what's going on. And ultimately that doesn't really, Trump doesn't feel the pain. DOGE doesn't feel the pain. It's just money that the taxpayer pays for the harm to the taxpayer, which I think people should be compensated. But I don't know if there's a basis to have DOGE liable for obtaining the data, and maybe under different theories. Under fiduciary duty theory, if we understand the government maintaining this information as a fiduciary duty, there's third-party liability. This is kind of common law fiduciary duty principles. But under the Privacy Act, I don't think there's a way that DOGE would be liable as a private entity. If it is a private entity, certainly the government would be on the hook for that. But I'm not sure the administration really cares about that. And then the other question is, you claw back the data, but how do you know that they don't still have the data? How do you rectify the improper uses of the data that have already happened? How do we put the genie back in the bottle?
Yeah. No, I think those are all sort of great questions. So I think so just kind of two notes. One, I want to drop a little bit of a footnote on the sort of disclosure piece, right? One of the things the government has said in its briefing is, there's no harm here. We're all government employees. Parent the question of whether DOGE people are in fact government employees, but assume for now that they are. And so even if there's disclosure, it's just disclosure within the government. But I think it's important to recognize that the Privacy Act, right, was designed, in fact, to make sure that you can't disclose confidential information even to other government agencies, and in many cases, even to other people within the same agency without some legitimate need for it. There's a specific list of statutory exceptions that'll permit you to disclose that information, none of which apply here. So I think it's worth kind of bearing in mind that the Privacy Act is being violated, even if the only thing that happens is OPM ships a bunch of this data to DOGE, right? Because we wanted to make sure that you couldn't pass this information around. And, the reasons why, I think, are reasons that were very salient in 1974 and are becoming salient again here, right? The Nixon administration was using COINTELPRO, right, to try to gather information on people on its enemies list from across government agencies. And that was precisely what Congress set out to prohibit in the future. And I think we're seeing exactly that same kind of misuse again here. So just disclosure within the government, I think, is a problem. The broader question of sort of like, what do we do about it? I absolutely think this is a worry, right? So in normal circumstances, in the circumstances that existed more than, up until 4 months ago, right? If you got a court order that said, don't disclose this information to these people, sequester the data, destroy the data you have, I think you could reasonably assume that the government would obey that order. I don't think we can assume that anymore. We've already seen a number of circumstances in which the government has willfully disobeyed court orders. There are 2 contempt proceedings going on right now involving the ICE and the illegal shipping of people to El Salvador, where they seem to be just ignoring the orders. But there are others. The court was ordered. The court ordered the White House to allow AP to have access to the press pool, and then it didn't. There are temporary restraining orders on behalf of law firms that have been targeted illegally by Trump's executive orders, saying, hey, you can't actually refuse to do business with people who use these firms. The evidence suggests that they are actually nonetheless continuing to do so. So what do we do if the government just willfully ignores a court order is a much bigger problem than our case, but I think it is a problem that we are increasingly confronting. You know, it's if in fact the government has decided they will just ignore the rule of law, they will just ignore binding court orders, we don't live in a constitutional democracy anymore.
Another relevant place, Dan, to where this is playing out right now is the litigation over access to security, to SSA information that's unfolding in the District of Maryland. So there, the judge did issue a temporary restraining order saying that DOGE should not have access to it. And there have been untold ups and downs to how the career staff within SSA and the DOGE employees appear to just be in a battle royale about what that actually means. The Washington Post had a really good in-depth story kind of chronicling the highs and lows of that, including now multiple resignations of people who actually were named under Trump to their role, but didn't feel comfortable violating the terms of the TRO and receiving so much pressure for them to do so. So we're seeing this play out in real time. There was a hearing in that case up in Maryland on Tuesday. And again, it's just another example of seeing how does the rule of law play out here. If the judge says that certain people are not entitled to access to a system and need clear justification for the access, is the rule of law going to hold? Are those safeguards going to hold? Or again, are we just in a free-for-all?
Can a court, mandate a kind of like a special master type of person to embed into DOGE and actually insert an officer of the court into these agencies or into DOGE to make sure that they are following the court's order? I don't know if that's within the power of the court to do, but that might be the step that has to be done rather than just kind of take their word for it.
Yeah, no, right. I think a couple of possibilities, right? If there is an injunction, right, and it looks like they are violating it, right. One thing you can do is the contempt power, right? So, and the notable thing about the contempt power is if you disregard a court order, it doesn't matter whether that court order was lawful or not. It doesn't matter whether you ultimately win on appeal. The act of disregarding the court order is an act of contempt, and you cannot engage in collateral attack on that contempt finding by saying, oh, the judge was out of bounds in issuing that order. Now, there are different types of contempt, and I think as a practical matter, that's going to matter. Criminal contempt, you willfully disobeyed my order in the past, can lead to criminal sanctions. Those criminal contempt sanctions, though, are subject to the pardon power. And so I think one of the things that people are worried about is that at the end of the day, even if a judge holds entities in criminal contempt for failing to comply with a court order, Trump simply pardons them and nothing ends up happening. That's not a reason not to do it. We still want the rule of law to and the process of law to be upheld, but it may mean that as a practical matter, they don't face consequences. But there's a second form of contempt, and I think that's an important one. Civil contempt. Here, despite its name, civil contempt is something that can and does put people in jail, and it can put people in jail indefinitely. And the idea here is, I have ordered you to do something with an ongoing effect. You have refused to do that thing, and I will put you in jail until you comply. And the courts have permitted indefinite detention under civil contempt on the theory that the contemnor holds the keys to their own jail cell. If I tell you, disclose to me what you did, right, or engage in a particular act, you refuse to do so, you can get out of contempt whenever you actually comply with the court order, but until you do, you may end up in jail. And because that contempt, even though it involves a jail term, is civil, not criminal, it is not subject to the pardon power. So I think one possible thing we might see is the use of civil contempt to throw people in jail who are not obeying the court's order unless and until they do obey that court order. The second, as Dan talked about, is the possibility that you could essentially put a department or agency into receivership. And that has been done primarily at the state level rather than the federal level by federal courts in the past. But I think it is something that is within the power of the federal courts to say this agency is simply not being run in compliance with the law, that previous injunctions and efforts to try to force that compliance have failed, and you could order a special master or some sort of a kind of a adjudicator to oversee the agency and enforce compliance. Again, the question of sort of where are we at the constitutional crisis stage, does all of this in some sense depends on the court's ability to enforce its order, and that depends on some level of compliance by the government. If they just choose to ignore the special master, it's not clear what you can do about that. But I think there are steps that can be taken if the political appointees are not obeying court orders to try to at least ratchet up the enforcement mechanism.
Yeah, and it's an important and interesting question about whether the administration will comply with orders once they receive them. To get to that stage, you have to win your case, and so there are about 22 DOGE cases out there. I think 3 of them have gotten either TROs or preliminary injunction motions. And so I think the focus of a lot of the lawyers who are running these cases is let's get to the preliminary injunction stage. Let's win that. Let's put the pressure on the government to comply. And when that next step, that next step will happen at a different point.
Quick question on something Mark said about the civil contempt jailing. It still does involve the executive branch, right? So if the executive branch says, we're not going to arrest we're not, because I think they control the marshals, right? We're not going to arrest them. We're not going to put them in jail. Can the court bypass that? So he doesn't need to pardon. He could just say, no, I'm not going to.
Yeah, I mean, so. Right, can the court bypass it again? Right, I think the answer is sort of where are we in the sort of transition from constitutional democracy to authoritarian dictatorship, right? And if we're sufficiently far along that line, that's right. The court has no actual practical power. They don't have their own jail cells. I mean, I think what the courts can do is they can instruct the marshals to arrest the person, to hold them in jail, right? If they don't do so, they could issue a bench warrant. But if at the end of the day, no law enforcement official is willing to enforce the law, the actual practical power of the judges to incarcerate people is going to end up being pretty limited.
Maybe the court could just stick them on a grand jury. Some other cases involve, does anyone know some of the other actions or following some of the other cases? I guess we're still litigating the merits of those cases, as Mario said. And I keep thinking of the famous line that it's still not clear actually who originally said it because it's always been misattributed. But a lie can travel halfway around the world before truth gets its pants on. And we can adapt it to, what they're doing with the data and all the measures they're doing kind of gets halfway around the world before the law gets its pants on. And, we're still trying on the cases, but by the time like this all gets resolved, they're going to have used the data. They're going to have exfiltrated the data. Who knows who all has the data? I mean, all the different DOGE 20 somethings, might have it on their phones or their laptops, or who knows where it's going to be. So I just wonder if the speed of the law is just too slow here to really effectuate, to really stop what they're trying to do. By the time the law gets involved, they've already done it.
A couple things to watch here, and it's not the same as a ruling in a legal case, which is obviously the remedy that one actually wants. But number one, we are seeing more resistance from career employees and others who want to be on the right side of history, taking a stand in government, leaving over this, refusing to comply. And people say courage is contagious. I think that's certainly the case. And we're seeing more and more instances of that, whether it's at IRS or at SSA and many other agencies kind of across the board. And again, these are people who, in many cases, came into power and assumed these roles under Trump, and they themselves are refusing to comply with the orders, showing how extraordinary they are. The second thing is the role of whistleblowers. We've mentioned, even in the course of the conversation so far today, some really in-depth reporting that is emerging from whistleblowers. The NLRB revelations about just how much information appears to be extracted from case files and case management there. Extensive whistleblowing from within the SSA and IRS as well. So investigative reporters are doing their work, whistleblowers are doing their work to shed more light and more understanding. And then the third really important mechanism, of course, is FOIA requests. And that's an interesting body of litigation to be watching right now. There are a large number of cases trying to FOIA information from DOGE. DOGE has been saying that it is not subject to the FOIA rules, and that is being contested and litigated in court now. Citizens for Responsibility and Ethics in Washington, for example, just got an order yesterday on discovery that DOGE is going to have to participate in to try and substantiate their claim that they shouldn't be responsive to FOIA requests. So we're seeing more progress there that I think also gives us glimmers of hope. Again, one hopes that sunlight will have its intended disinfectant effect. We need stronger interventions than that ultimately, but at least getting more visibility, more clarity into what's happening, and having reasonable people speak out and say no is one piece of the puzzle we can be pushing on right now.
Yeah, and I think just to give a few concrete examples to what Alexandra was talking about is, in our case, there's a public record. There's also the same public record that's in one of the Maryland cases. And in the public record, in those two cases, show that access inside of OPM was being given. The Washington Post on a specific day reported about that access and that disclosure, and it caused a lot of alarm bells. The next day, the public record shows that some of that access, some of it, not all of it, but some of that access in response to the Washington Post story got rolled back. And so just the reporting itself, the illumination of that fact itself did some work. And then in addition to reporting, I think the filing of lawsuits does work as well. And so our lawsuit was filed in early February. The next day in the public record, it shows that the OPM started doing an audit. We don't know if that's because of the lawsuit, but the timing is very coincidental. And so I think both reporting and then the lawsuits themselves actually being filed do have an effect of changing perspective and sort of activity inside the agency.
One other potential cause of action that I haven't seen, but maybe it is going to be brought, is the constitutional right to information privacy. It's a right that's kind of been a little bit unclear from the court if it recognizes this right or still will recognize this right. Actually, the last opinion on it was an opinion by Justice Alito, who kind of took an agnostic view on it. But it's recognized by most of the circuits. And it basically says that the government can't engage in an unwarranted disclosure of personal data. It focuses on disclosure. So if the disclosure is an improper disclosure and there's a balancing test, that could violate the constitutional right to information privacy. And so at least at the circuit level, it's very well established in a lot of circuits. It's just, the Supreme Court, who knows? But that's another avenue, which would then have, all of the kind of constitutional Bivens relief that you would get if there's anything left to any of this. But another possibility. And then, there's FOIA, which is the Freedom of Information Act. Can you gather information? That wouldn't stop it, but I think as Alex and Mario pointed out, it does help to shed light, and that then helps to either bring additional lawsuits, find out what's going on. I guess one of the challenges is, making a FOIA request can take a while for, the government to respond with the information. And it does, and a lot of the people who may be responding, I don't know if they're still employed. So I guess it takes courts that would really, have to push the government to respond to the FOIA requests to get that information. But I hope that there would be some FOIA actions being brought to find out what's going on, because so much is happening. I would figure that there should probably be, hundreds and hundreds of FOIA requests submitted. And the way FOIA works is that anybody can submit a request for information without, they don't need a justification for it. They just want to know, and they can make a request. And as long as it does not fall under one of the exemptions under FOIA, they're entitled to get that information from the government. But it then does require the government to produce the information. And if the government doesn't, then you could sue under FOIA. But that's a long process.
Yeah, right. I think that's going to be a longer. I think it's absolutely worth doing. It's going to be a longer term process, in part because I expect the government to stonewall as many of those requests as possible. The other thing worth noting, by the way, is what we have kind of learned so far suggests that, right, all of the kind of formalities associated with public records are just being violated willy-nilly in this administration, right? So start with DOGE, right, where the whole question of is DOGE an agency or not, right, I think triggers a bunch of those things. They are very much trying, I think, to have it both ways in order to kind of not have public records, public meeting requirements, financial disclosure requirements, and the like. But beyond that, right, there's the whole use of signal and other means of communication that are deliberately designed to be outside the public record, right? We happened, because of this weird accident, to find out that national security business was being conducted on a private signal server. There's no reason to think that that was a one-time event, and every reason to think that this is something that has been going on a regular basis by multiple agencies, and it's just that they happen to get caught because of a particular act of stupidity of including an Atlantic reporter on the signal chat. So I think one of the interesting problems is going to be right, how do we, what will I get the records that are nominally public records, but how do I get access to the information that should all in fact have been communicated in a way that was accessible under FOIA, but which we did not in fact obey the law in communication. And that's going to be more challenging. There is at least one order already out there requiring that the government preserve signal messages. Whether they're doing that, again, hard to say.
Well, I guess one virtue of bringing a bunch of FOIA suits and pressing it is it does eventually going to get something on the books to pin DOGE down. Agency where it's has it both ways. But if you pin it down as the government, then certain things kick in. If it's not the government, then other things kick in. But right now it's trying to have its cake and eat it too. But I think if it ever gets pinned down as one or the other, once that gets established, then that hopefully would stick and then apply to all cases going forward, and that would at least help stamp out that kind of have your cake and eat it too problem.
Yeah, I think it's getting pinned down more and more as a government agency that is subject to FOIA and the Privacy Act, and so the Crew lawsuit that Alexandra was talking about earlier has gotten a preliminary injunction motion that said DOGE is an agency subject to FOIA, and they have to respond to Crew and everyone else's requests. Perhaps not, then you have a back and forth about what gets disclosed and how much redactions happen. But a court has already said that in terms of FOIA, DOGE is an agency subject to the law, and the definition of agency in FOIA is the same definition that is in the Privacy Act, and so EFF and Lex Lumina and a few of our colleagues, we've brought the case against the Office of Personnel Management, but we've also named DOGE as an entity who is subject to the Privacy Act. And as you said earlier, the Privacy Act has a lot of provisions. It has a disclosure provision, but it also has cybersecurity provisions. And so we've sued DOGE specifically under the cybersecurity provisions, saying that the information that they have received from OPM, they haven't been protecting it properly. They haven't vetted their employees. They haven't trained their employees. They don't have access controls and oversight over their employees. And so, that is another avenue to go after DOGE under the Privacy Act. But there's also like different and sort of coextensive powers under the Privacy Act that mirror FOIA. And so under the Privacy Act, you as an individual, if you're a person whose information is held by the government and you think DOGE has obtained it, you can seek that information, just an accounting of that information from DOGE. And I think Representative Jamie Raskin has encouraged some of his constituents and the general public to do that. And also, if DOGE is collecting that information, but not keeping that information in a correct format, you can petition DOGE to correct the information if it's holding information on you that is either irrelevant or not correct. And so I think those are two other tools in addition to FOIA that the public should be empowered to use directly. You don't have to file a lawsuit; you just have to file a piece of paper with DOGE. And I think Representative Raskin has probably encouraged thousands of people to do that already.
Any other thoughts on generally what can be done addressing these issues? Beyond the cases being brought, are there other cases that could potentially be brought, other avenues, laws that states can do, things that courts can do? I think the constitutional right to information privacy is one. There could be potentially Fourth Amendment, but the way that the Supreme Court has interpreted the Fourth Amendment does put some limits on it. There's First Amendment if this data is being gathered to target people for their speech. I think the Fourth Amendment applies beyond just the collection of data, but it also applies to government access and use of data and retention of data. There's nothing in the Fourth Amendment that, I think would necessarily limit that, at least if you're looking at the intent of the Fourth Amendment and the text of the Fourth Amendment. Unfortunately, the way the court has applied it has been narrow, but, there are possible avenues there. Anything else that could be that could be used or is necessary for protecting privacy in the times we're in now?
Yeah. So, I think this is a hard problem, and this is not maybe a solution as much as a sort of like, here's some more obstacles to think about, right? But I want to sort of back out a little bit to a broader view, right? Which is so much of our discussion about privacy in the last 20 years has been focused on private company access to data, right, rather than government access and misuse of data, and has been focused on state rather than federal legislation. And I think one of the things we're seeing as we see a government that is just sort of not willing to comply with its obligations under the Privacy Act is that the tools that we have are not necessarily up to the task. A state privacy law, right, which I think has pretty clearly been violated in this case, is not going to work as applied to a federal government employee under Tennessee versus Davis. And the federal laws, I think, do apply, right? But the courts have already started to hamstring them. So one thing we could think about is, can we get a more effective federal privacy law, right? Should we amend the Privacy Act? I know there are folks on the Democratic side in Congress who are already thinking about how could we do that? How do we fix some of these loopholes? One challenge is that the Supreme Court has been, as previously mentioned, extremely aggressive in trying to override the terms of the statutes and impose not just interpretive limitations, as in FAA versus Cooper, but also constitutional limitations related to standing, right? So most notable here is TransUnion versus Ramirez, where the Supreme Court 5-4 said that a statute that expressly said you are entitled to statutory damages if this happens did not create Article 3 standing because Congress, it said, had no power to create a new cause of action that was not sufficiently similar to causes of action that existed in the 18th century. That is utter nonsense as a matter of constitutional law. Even Justice Thomas got off the boat at that point and said this is not actually the way things work. But the majority of the court said in TransUnion, no Article 3 standing because the fact that you're entitled to $2,000 in statutory damages doesn't create an injury. So I think that's going to make it really challenging to bring a statutory cause of action, even under a better statute, maybe even a constitutional cause of action, right? Because you don't have standing to bring that claim, even though you have been injured. One thing that it might allow, right, is you to bring a federal claim in state court, right? Article 3 limitations on standing do not apply in state court. That's going to present some interesting constitutional power questions. I don't think you can bring a state claim in state court against the federal government, but you might well be able to bring a federal law claim in state court against the federal government and get around some of those standing.
And Dan, the one additional issue that we can't end the conversation talking only about kind of government collection of use of data without also talking about the role that companies are playing in the current landscape. So in two different ways, right? One is, developing the tools, providing the platforms and services through which these efforts can be implemented. There was extensive coverage just this week of a new deal between Palantir and ICE, an additional surge of their existing contract with ICE, for them to be facilitating the identification and prioritization of targets for removal, despite knowing the very egregious risks and abuse of the rule of law that we've seen in recent cases with people being wrongfully removed and then the administration making no efforts to fix those errors. So there's that piece of the puzzle. And when you think back to what happened during the first Trump administration, where there was a really rigorous public debate, both of employees in these companies and advocates and community members on the outside, thinking about what it is to be complicit. And we need to be having that conversation this time around as well, and make sure that that is being surfaced. But the other piece that's relevant for your audience in particular, Dan, knowing how many privacy officers and others dial in, you may well have folks that are not themselves, creating tools for surveillance, but they may well be gathering information about people that can be useful to and misused by law enforcement. So now is the moment to be thinking about how you as a company are collecting and processing sensitive information that may reveal somebody's health, that may reveal somebody's pursuit of gender affirming care. How well are you maintaining those records? Are you following appropriate data minimization principles? Do you have the right mechanisms in place to make sure that you are only complying with legal process, not fishing expeditions? And that type of work is something that privacy professionals across the ecosystem not only can be doing, but in my mind must be doing right now in this moment where privacy is the tool through which we can try and take a stand and offer some protections to people at least.
I'm so glad you made this point, because this is a point I make in my book. I have a new book on privacy and technology. It's my background. And I make it in a paper I wrote on privacy in authoritarian times. And that is that government surveillance and surveillance capitalism are two sides of the same coin, that, the government can access troves of data that are being collected by private companies. And that data can function as government surveillance, and they can readily get it. If you criminalize things like, now after Dobbs, abortion can be criminalized, and then even with a warrant can get data from companies. a government can just call anybody a terrorist and say, well, you're a terrorist if you, spray paint a Tesla, and then use that to gather data from various apps and various other companies that are hoarding all this data. And so we need good regulation of consumer privacy and the data that companies have and how long they can keep it and how they can use it. If we really want effective protections against government surveillance, you need to at least address that. Not that the states have taken a role on that, and big states like California and states like New York and Massachusetts, which may eventually kind of come in and weigh in on these issues with their own laws, can pass stronger laws that would try to protect this. And also the design of surveillance technologies. A lot of companies are building tools that the government uses, and they build these tools with no built-in privacy protections into the design, no accountability mechanisms, no mechanisms to limit them, no mechanisms to audit them. But if these were built into these technologies, then we could find out like what is DOGE doing and did it collect the data, because technologies would record and audit that. I think the states could mandate that. If a state like California says, you need to do this in the technology, it could apply nationwide, and then we'd have technologies that are more accountable and better.
And I think that's maybe an important sort of point to think about as we sort of confront the world that we are increasingly in, right? Right. So we've been talking about what we're doing as a matter of law, what are the potential limits of the law, right? But I think we might at some point need to sort of face the fact that we're not living in a free country anymore. I hate that. I hate saying it. But, Sebastian Gorka, right, who's an administration official, told us yesterday that everybody on this call is a terrorist because if you speak up for due process, that makes you an aiding and abetting of terrorism, right? In a world in which we are living in a repressive government, right, one of the things that people need to do is to rethink, how does one actually survive in a repressive environment, right? And one of the things, to go to Dan's point, right, is to think about, right, what technology can do, how that technology is going to be misused, what limits we can put on that technology as a practical matter in order to continue to try to maintain sort of privacy and rights in a world in which we can't rely on the law to do it for us.
Yeah, I think I totally agree with that, and I think we have 4 lawyers on the panel, so we're talking about the remedies you can get through the law. But EFF, half of or a third of our organization is made up of activists. A third of our organization is made up of technologists who are actually building privacy preserving tools, and then we also have investigators on our staff, and then that is definitely supplemented with reporters from just the general community. I think, investigation, activism, and then sort of just privacy preserving technology are all remedies. They're remedies outside of the legal space, but I think those are all tools that are in sort of the public interest toolbox at this times.
Yeah, and I also want to emphasize, state legislatures do have some power. If they wrote better privacy laws, it can help. I think courts have power. Mark was mentioning, the standing cases and TransUnion, and it's actually part of a trio of Supreme Court standing cases, beginning with Clapper, and then there's Spokio, and then there's TransUnion. And the court tries to kind of close the door or make it really hard to get standing, even when there's a private right of action in a law. But the court, it's playing around with I think lies and fictions, and when it does it, and there's still a lot of wiggle room because the court really can't totally close the door in a coherent way. That opens the door for lower courts to, I think, pretty readily, if they are inclined to do so and they know about the law, they could find privacy harm in a lot of instances. There's a lot of analogs in the common law for privacy harm, including 100 years and more of privacy law cases, which a lot of judges just don't know. And I read all these opinions saying, oh, it's not similar to the common law. And I can point to a gazillion cases that are similar to the common law. Or courts saying, oh, we don't recognize harm for pure emotional distress, and they do. That the privacy torts do it for 100 years, and it's not even a controversial issue in that body of law. So I think there's a lot of room for a court, if they want to find harm, they can find harm if they study the law. I wrote a paper with Professor Daniel Citron about privacy harms, looking for bases in the law and arguments there. So and we're not alone. There's a lot of stuff out there that courts can take the Supreme Court's invitation to say, okay, now we have to play this game of finding something, in the common law. They can find something in the common law, and they have. The Fourth Amendment, Carpenter opened the door, and the court said, well, we want to be really cautious. But ultimately, that doesn't mean that lower courts, using that opinion, can take its logic to its conclusion and can be bolder in what it does, and make the Supreme Court do its work. If the Supreme Court doesn't like it, Supreme Court can say, whoa, that's a little too fast. You pushed your logic a little too far, but make the court do its own work. But a lower court judge could very plausibly, within the precedent and totally logically and reasonably, be a lot bolder than what courts are doing right now. And I think the same goes with state legislatures. I think there's a lot of room in the existing law to be a lot bolder than what courts are currently doing, if they want to. And I think now is the time to be bold. And if make the Supreme Court hit the brakes, but don't hit the brakes. Don't do their work for them, and don't hit the brakes for them. It would be my advice there, because I think there's a lot of room in the law to do things that are effective. Thank you all for joining me. I wish we had more time to keep going, but I will stop here. We're a little over the hour, and I'm sure there's going to be more to talk about. So maybe we'll revisit this maybe in a day, because there's so much news that it seems that every day brings new things going on. But thank you all. I really appreciate your spending this time to talk about these issues and bring these cases.
Thanks so much, Dan.
Thanks.
Thanks, Dan.